Hello, everyone. My name is Thane Rosenbaum, and I'm the creative director of the Forum on Life, Culture, and Society at Touro College, and in association with our longtime partners, the 92nd Street Y. Welcome to Law of the Land, the Supreme Court's Year in Review. This is a wildly successful program that we have every year. We hosted with the 92nd Street Y. 6 years ago, when Susan Engel and I from the 92nd Street Y thought of the program, we had, no idea how successful this would be. But people are genuinely interested in the Supreme Court, which is generally opaque, and people are interested in the cases, but they want to know what they mean. And so we provided every year an accessible and for discussion about the court's year with the celebrity guests of panelists this year. I'll introduce you in a moment to them. But it was an extraordinary year. The pandemic, COVID-19, had a large effect on the Supreme Court, and they've had cases on immigration and abortion and presidential powers and religious liberty and LGBT rights. So it was a big year, interesting year. And so here to discuss, every year we rotate our guests. And so this year we have, they'll wave to you in a moment. First, Adam Liptak, who is the Supreme Court reporter for the New York Times. Adam is an old friend of Folks. He's been on our program a number of times. And Dahlia Lithwick, there's Dahlia, there she goes. Dahlia, she is a senior editor and legal analyst for Slate magazine. And she is also an legal analyst for MSNBC. And Dahlia has been a guest of Folks also from the very beginning. So welcome back, Dahlia. Lisa Green, who is very new to us, but we hope to invite her back again. There she is. You've probably seen Lisa as a legal analyst on MSNBC. And I've known Lisa from when we were both associates as young lawyers. And also a new guest for us this year is Tiffany Graham. There's Tiffany. Tiffany just joined the Touro Law Center as a constitutional law professor. So she's new to us and she's new to Folks. And I thought this was a wonderful way to introduce her to a national audience. So welcome, Tiffany. Before we start, I'm going to undertake a prerogative since I am the founder of Folks. So for this night, I'm going to just step out of line just slightly. And we call this every year Law of the Land. But tonight we're going to call it Adam's Angels. It's a different program altogether. I can see he doesn't like it. I'm not sure this is politically correct. But look how handsome he looks there, surrounded by his guests, celebrity guests.
Have you heard of cancel culture thing?
I'm pushing boundaries now. I don't know if we're allowed to do this, but we're going to try. Come on, you look great up there. Adam, we should start with you. Oh, and by the way, if you have questions for our guests, you can do so with the live comments section. Leave some questions throughout the evening, and we'll hopefully get to one or two at the end of the night. Adam, we should start with you because this was an unusual year on at least the operations of the Supreme Court. The oral arguments essentially shut down for 2 months. They rescheduled oral arguments, pushed them over to the next term. I think there were 10. There were a number of unsigned opinions. And when the Supreme Court got back to business, it didn't actually show up live. So why don't you tell us, since you covered it intimately, what was the experience like this year? It was unlike any other year, right? And nothing like this has ever happened.
It was very different. The main innovation was that the court heard 10 arguments by telephone conference call, which by Supreme Court standards, launched them well into the 19th century, maybe the 20th century. They allowed live audio so the public could listen in live. And both of those things were great. That's, God bless them. That's a real innovation. That's to the good. Clarence Thomas felt comfortable participating. Hearing from him was good.
Well, no, can you explain that for many people? Most people don't know. There is a little thing about Clarence Thomas that not everyone knows, which is that
Clarence Thomas very seldom asks questions at oral argument. He says he's given a number of reasons, but the main reason he gives is that he thinks it's rude to the advocates to interrupt them constantly. And an in-person argument in the Supreme Court is, as he put it, a kind of family feud with everyone interrupting everyone else. Now, to my mind, that's actually organic and useful. So the second part of what I thought was a brilliant innovation on the part of the court was made problematic because the justices asked questions in order of seniority for about 2 minutes each. There was no interplay. The Chief Justice was cutting people off. And nonetheless, they went not the usual hour, but close to 2 hours. And it was a stilted, unhelpful format, tough for journalists because it's hard to tell who was on which side. So there were pluses and minuses. And at the end of the term, they managed to decide only 53 cases, fewer than any since the Civil War era. But nonetheless, they got through it somehow, and they yielded, and we'll talk about this, I'm sure, a bunch of very interesting decisions.
So, and this is all of you. I mean, it's sort of a morbid question of sorts, but I think it is an important question. We've all read as of late that Justice Ginsburg was checked into a hospital where she was admitted, I think, for 2 days. I don't know if she's yet has left the hospital.
She was released yesterday.
She was released yesterday. And for people who are court watchers, again, there has a kind of morbid fixation. When I was covering for CBS News the court, when they stopped oral argument, I reminded the listeners of CBS News, look, we know that the most vulnerable demographic for COVID-19 are the elderly. And it just so happens our Supreme Court are made up of really elderly people. And so, of course, they're not going to show up and expose themselves to their young law clerks and everyone else in the building. So I guess that added a different dimension this year. That and the fact that there's speculation that there's 4 justices that have reached an age that they may be imminently seeking retirement. Ginsburg, Breyer as liberals, and Thomas and Alito on the conservative side. So can we maybe talk a little about this, about the relationship between, that health has high stakes when it comes to the Supreme Court?
Well, I'll jump in and offer a quick thought on that. When we have this conversation, we so frequently focus on Justice Ginsburg, but, well, those of us on the left, really. And I will say that I don't think we pay nearly enough attention to Justice Breyer because he is nearly the same age that she is. And while he doesn't have the same history of health concerns that she does, that doesn't matter. And so, I mean, if he were to suddenly pass away, as Justice Scalia did, the dynamics would be exactly the same if it happened between now and January if Trump were reelected. So, I mean, I think that, with all of the conversation that we have about Justice Ginsburg, I would love to see us talk about Justice Breyer too, just because it, I think, highlights the fact that for those of us for people who are on the left, the concern is actually more acute than we tend to think it is. And that might actually help concentrate voters' minds even more than they currently are.
Can I just make one point here about Breyer, who has been a guest at Folks before? So I hope he won't be upset if I reveal this. He's dangerous on a bicycle. He's fallen off a bicycle twice. I think the funny part about it was the both times where he was interviewing with Bill Clinton. I think one time he went to interview him and he wasn't picked because he wasn't feeling well on that day he showed up to the Oval Office because he'd fallen off a bicycle. So I just want to say, Tiffany, if we keep him off a bicycle, there's a really good chance he'll live long.
Okay, good.
I'm not a particularly spiritual person, but I want to make a quick point about RBG, which is to say, and picking up on what Tiffany said, Breyer needs more love. I had the great pleasure of meeting Justice Ginsburg, not in the Supreme Court where I've only been once, but at the revival of Fiddler on the Roof in the before times when we could go to plays. And at intermission, she was introduced along with Kate McKinnon, who plays her on Saturday Night Live. And the crowd went wild. She is so well supported spiritually that I personally think she's going to live to be 200. We just got to send some other justices a little bit of that love.
And if I could just say one quick thing, I would say, just to echo what Tiffany said, I think there's a lot of anger on the left directed at Justice Ginsburg for not stepping down when she could have. And I think it's absolutely correct that there's no corollary, both in terms of Justice Breyer and Justice Stevens, who also stayed on longer even than Justice Ginsburg. And I think that there's a lot of really interesting analysis that has been done about why Justice Ginsburg really refused to step down, even amidst a lot of pressure when Obama could have replaced her. But I think at the nut of it, I think she found a lot of the criticism for I think what is undergirding what Tiffany said was quite sexist, and that she was being held to a standard that no male jurist was being held to. I will add that the fact that we are on this like very, very, I agree with you, sort of morbid roller coaster of watching hospitalizations. And we should note that the Chief Justice also had an injury this year that took a really long time for the court to disclose. But I think I would just add that, to me, the fact that there is without doubt 5-4 court right now, all of the conservatives appointed by a Republican, all of the liberals appointed by a Democrat, for the first time, right? This is a shocking change from what we're used to. The fact that despite that, and despite the fact that this was, I think, the biggest term of my 2 decades covering the court, that it was not a 5-4 route, and that this was not, oh, well, you know, Justice Ginsburg really blew it, I think is really the most interesting part of this story. And the hyper focusing on her rather than the fact that the court did not do what it ought to have done is the really, really interesting coda.
Well, that's a nice segue to my next question. And I can ask all of you this, although Adam, you might want to take it first. This was the year of Roberts in many ways. The Chief Justice in divided decisions showed up voting with the majority liberals more times than any other Chief Justice has since 1953. Is Roberts, from a conservative standpoint, is he the new Souter or is he the new Kennedy?
He's certainly the new Kennedy in the following sense. He's the justice at the ideological center of the court. He's the deciding vote in many closely divided cases. That does not make him a liberal, far from it. There were 12 5-4 or 5-3 decisions. There were classic lineups, which is to say the 5 Republicans in the majority, the 4 liberals in dissent, in 8 of them. So in 8 of the 12, you have precisely what you'd expect. In 2 of the 12, DACA and abortion, you had the chief joining the liberals. In a case on Indian rights, a very significant case, you had Gorsuch joining the liberals. And in only one case, you had a scrambled lineup. So that gives you a sense of where the chief is. But nonetheless, it's possible for some liberal commentators to overstate things and say, no, it's all a shell game, it's all strategic, it's all tactical, he's playing a long game, don't believe any of these victories. These are authentic liberal victories that came out of the Supreme Court. Gay and transgender and bisexual people are better off because of the Supreme Court. They now can't be fired. That's right. Fantastic. Louisiana has 3 abortion clinics, not 1. And you could go on.
We'll get to the right. Or so say Adam would say that last point you said?
Those are real gains for the left.
Yeah.
And there's a tendency to look a gift horse in the mouth.
Right.
It's possible to find things in the Roberts concurrence in the Louisiana abortion case that might make it easier in the next abortion restriction case, and that's true. But listen, if you get liberal victories out of this Supreme Court, you should be glad.
But would you also say, given what you just said, maybe someone else will jump in here, that Gorsuch and Kavanaugh and Roberts together appear to be more centrist?
Well, again, centrist is one word, and it depends on how you define it. They are now the soft middle of the court. If an advocate is going before the court and wants to pick up one more liberal vote, that's where it will come from. It won't come from Thomas or Alito. But being centrist on this particular spectrum doesn't make you centrist in the American political vocabulary.
Although I have to assume that conservatives that applauded President Trump's selection of Kavanaugh and Gorsuch are probably not happy with the fact that Gorsuch and Kavanaugh ended up on a number of cases either siding with the liberals or playing a role that is much more centrist in nature.
So Kavanaugh hasn't cast a vote that's really disappointed his supporters yet. Gorsuch certainly has, and the chief is now persona non grata at the Federalist Society.
Anyone
And I
else?
think it's just worth saying that there's a perfect mirror of that on the left, where we've seen that Justice Sotomayor and Justice Ginsburg have really become a kind of inflexible left wing of the court, and Justices Breyer and Elena Kagan have kind of drifted, and for exactly the mirroring what Adam just said, it does not make them centrists. They're still liberal. But I think that to the extent that there are kind of 5 justices in play, rather than just one, is really different.
It must drive the justices crazy. I'm just speculating, to be put in these boxes, right? If you look at Justice Kagan, and I'm just going to go ahead and mention the CFPB case, she authored an article called Presidential Administration, arguing that it was not a bad idea to have the executive branch monitor, right? So the idea that she has to either be like guest hosting on MSNBC or she's dead to you if you're on the left feels just primitive to me. Where the room for nuance, that's what judges have to do sometimes.
Right. Can someone just quickly answer a question I sort of asked before quickly to Adam, but I think it's important that our audience understands what my joke was. I like when my jokes have meaning, which was, is he another Souter or is he another Kennedy? Adam immediately said, well, I don't know about Souter, but I know he's another Kennedy. Now, the reason I said Souter is because, why did I say that?
Because Souter was appointed, as I recall, by Reagan. And so there was a sense.
George H. Bush.
Oh, okay, yes. Well, in any event, by a Republican. And so the sense was that Souter eventually became a turncoat. And I don't think that there is any reasonable, rational perspective that one can bring to the table that he's a turncoat. Roberts is a conservative. He just is. And Adam, I'll disagree with you a little bit on June Medical. I do agree that it is it's a liberal victory right now. These abortion clinics in Louisiana are still open, but as you said, there's language in the opinion that Chief Justice Roberts offered up to the conservative legal movement for how to actually appeal to him next time. So that's why I say, number one, that he is no Souter, but number two, I do think that the short-term victory has such seeds for fear that the left really needs to pay attention to.
We'll definitely come back to that. And that is an important point, that even in instances where it appeared that there are victories, there's also a roadmap that's being offered for how to do it right. I would even say you could make the same argument with the DACA case, which we'll get to as well, that another roadmap was, well, yeah, you didn't do it right, but you could go back. The problem with Donald Trump is he doesn't have enough time to go back at this point if he was to try to have it have an effect on the election. So let's start with the first case. And I'm going to start with you, Lisa. Trump versus Cyrus Vance Jr. I think it's also Trump versus Mazars. This is the subpoena cases issued by the Manhattan DA's office, Cyrus Vance Jr., as well as one or two House congressional committees seeking tax returns and financial documents of President Trump in connection with the hush money payments and foreign influences in his campaign. The president asserted, his immunity to prosecution, privileges. He said, he told his accountants and he told his bankers, do not give my tax returns or my financial records to these entities. And so in a moment, you'll tell us about the case and why that's important. It's a decision that President didn't like, although it's not clear whether it would affect them between now and the election. But before you begin, Lisa, I have to give you fair warning, which is that Cyrus Vance Jr. is watching. He's an old friend of ours. He's been a guest here a number of times. In fact, I think he once appeared with Dahlia years ago. And so you should know he'll arrest you. So, this guy makes Javert from Les Miserables look like milquetoast. So I'm just saying, in an hour, someone will be at your door. So just be very careful on what you say. Tell us about Trump v. Vance.
Okay. On advice of counsel, although she who represents herself has a fool for a lawyer, I'll say nothing other than it's wonderful to know that District Attorney Vance is on the phone, on the call, and also well played.
His wife Peggy is here watching too.
And
Yeah.
Mrs. Vance. Well played. And of course, he was at the winning end of this two-part decision, 7-2, Justice Roberts writing, and significantly here, making it very clear that the president is not above the law, certainly when it comes to subpoenas. By the way, 2 words for those who have forgotten him: Michael Avenatti,
Yeah.
kind of the architect, for all, love him or hate him. Those were heady days if you were a legal analyst on TV talking about Stormy Daniels. So really, like, I think Adam called it stunning in the Times, an amazing decision because, Roberts characteristically looking carefully at the balance of power, bowling this proverbial ball down the middle and just emphatically saying that the prosecutors have the right to this material, I know now there's going to be a second round of quarreling about the scope of the subpoenas. I think I read in the paper that the president's lawyers want to collect evidence maybe and have a full-throated hearing about this. I don't think the judge is going to stand for that. Sadly, for those of us who are former journalists and therefore voyeuristic, we won't see these documents anytime soon, but it certainly felt satisfying as someone who believes in the rule of law to see this decision come out. Of course, the congressional part, which seemed to me the weaker argument, surely disappointing people in Congress who think they really ought to be able to, that they can't really conduct what's central to their mandate. Right?
They're an investigative body.
And how can you do that when you don't have access to these documents? Roberts basically said, you're going to have to make a better argument here.
But let me ask you this about this case, which is surprising to me. So Kavanaugh votes with the majority in this case, right? Right? Was Kavanaugh, he votes. My memory is, and I wonder if anyone wants to speak about this, during the confirmation hearing, people oftentimes pointed out that he wrote a law review article at some point early in his career, in which he said, presidents are very busy. They're super busy. I worked for President George W. Bush, and I do not think that they should be subject to prosecutions or investigations while they're in office. We can't. So it is interesting, right, that for the very thing that people thought that Kavanaugh was a safe bet for Donald Trump must really be shocked because he was told that this guy actually believes in presidential powers and that these powers are really, really big powers, and they in some ways supersede the powers of Congress.
Kavanaugh's been a bit of a moving target on this thing because if you look back, he of course launched his legal career as part of Ken Starr's investigative team, and they didn't seem particularly concerned that President Clinton was too busy to deal with their inquiry. It's true that after serving at the elbow of George W. Bush as his staff secretary, he did take, and I have to say understandably, an expansive view about, what a usual and hardworking president, perhaps not the current one, the burdens that the president faces. But then finally at the confirmation hearing itself, in addition to the usual litany of cases that every nominee says, Marbury versus Madison, the Brown v. Board of Education, he singled out the Nixon tapes case as one of the Supreme Court's finest hours. So having heard that, this vote didn't particularly surprise me.
Anyone else on this?
Maybe just worth pointing out that it does go to the almost sort of laugh out loud funny scope of the immunity that was being claimed in this case, because I think both in Vance and in Mazars, the claims that were being advanced, not just by the president's lawyers, but by the Justice Department, were just, that the president, his entire family, immune even from oversight and scrutiny, investigation. These were documents. There was no claim of executive privilege. These are documents that were in the hands of third parties. And I think, like the joke about this case, right, is that at some point, one of the lawyers said, oh no, even if the president shot someone on Fifth Avenue, he would be immune. And I think Adam's point is exactly right. I think Kavanaugh was never a sure thing for this, but I do think maybe the fact that Kavanaugh could sort of throw in on this tells you more about the nature of the claims that were being advanced.
Right. Hey, Tiffany, let's move. Yeah, go ahead, Adam. You want to
I might tell you something, and then when we talk about DACA, we can touch on this. I don't think this court is particularly in love with Donald Trump. It may be in love with Republicans. it may be in love with presidential power, but this particular president has not had a good run at the court. The Trump administration is the first administration since FDR to lose more cases than it's won at the Supreme Court.
Right. That is an amazing statistic for this year, right? And a president who actually had 2 picks in his first term,
Yeah.
right? So that adds to how did that happen to a president to just had 2 picks, men who happen to have been on the, on the list of conservative judges who had been vetted, who would not break the hearts of conservatives. Tiffany, let's go to the Title VII case, because I know that's yet another surprising case in some ways. After Justice Kennedy retired, when we had Law of the Land a year ago, or whenever it was, 2 years ago, everyone said, God, what's going to happen to marriage equality? What's going to happen to the protections of LGBT rights? Who would have thought that after Kennedy retired, this would happen? This essentially extends workplace discrimination protections that would otherwise be given to race and national origin and sex, and extends it to gays and transgender. This was a big surprise, Tiffany, right?
Yeah, it absolutely was. I mean, I don't think that there were very many people who anticipated either a 7-2 decision or that Justice Gorsuch would be the one who would write it. But I will say that perhaps we should not have been quite so surprised given his history as a textualist. Andrew Koppelman is a legal scholar who's been writing for years about the importance of the sex argument, the argument that when you talk about sex in the context of discrimination on the basis of LGBT status, it's a straightforward argument. If you are discriminating against someone who is gay or transgender, you are doing so because you have an issue with either the choice of partner that this person has made because of their sex, or if they're transgender, you have a problem with the identity that they have as a result of their biological sex. It's a really straightforward linguistic argument, and that was the nature of the opinion in this case. And in fact, it was relatively short because it was so straightforward. So what I would say that's interesting to me about this case is the implications of that straightforward analysis. I mean, there's been some chatter about this that I think is, quite frankly, worth paying attention to. What happens the next time an affirmative action case comes to the court? What do you do with the language because of race? Is that going to be used to undermine affirmative action programs at private schools around the country? I don't know the answer to that, but I do think that this decision, as extraordinary and wonderful as it is, does lay some doctrinal groundwork for potentially undercutting those programs.
But what about the people who make a kind of sort of an original argument and say, hey, Tiffany, 1964, when Congress passed this legislation, they were thinking sex meant gender. And so if you believe that you toe to what the intentions were, whether they are founding fathers or whether they are congressional leaders in 1964, they were never thinking about gays and lesbians. They were thinking about men and women. That is an argument. In this case, you had Roberts voted with the majority. Roberts, who dissented in the marriage equality cases. Again, a year of Roberts. Why was Roberts with the majority here if he never liked the marriage equality to begin with? All of a sudden, he lines up in line with gays and lesbians and transgender.
I have lots of speculation about Roberts that I'm going to allow to be speculation. But what I will say is the interesting thing about the justices who adhere to originalist ideology. Originalism cannot overcome the text. And that was the point that Gorsuch was making. At the end of the day, the language is what it is. It says what it says. And so if you don't want to take the language seriously, then you can rely on the originalist, the original intent. But at the end of the day, Congress has the ability to alter the statute to reflect a more originalist intention if it wants to. And the fact that it did not, I mean, that gives license to the court to do what it is supposed to do, which is to actually take seriously the language that is in front of it in the statute. So, I mean, I don't have a great deal of use for originalist ideology because it's so easily manipulable. And I realize that the conservatives on the court would not agree with me as a general proposition, but certainly in this case, I very much appreciate what Gorsuch did in taking textualism seriously.
If I might, may I? Yes, there was an elegant description of the result Gorsuch reached. I'll cite to Walter Olson. He called it surprise plain meaning. What does that mean? It would be a surprise to a human being in 1964 who was drafting this law that this result would happen in 2020.
Or that it would be considered plain meaning.
But it would not be a surprise if you opened a dictionary from 1964 and looked up the word and saw the meaning there. And I thought that was one way to look at it that struck me.
But it is worth just saying, I would just say one of the fun things about the dissents in this case is that it was just a full-on, barroom brawl about the exact questions that you're raising. And, for those of us who've been sort of enjoying the intramural fight about original public meaning and textualism and construction and what all that meant in the academy. And, as Tiffany said, here's just a straight up, textualism, the thing that after, the Heller, the gun decision, we were all supposed to be, now we're all textualists. And so just, I have to say there's some fun in, Sam Alito with his pages and pages and pages of dictionary descriptions, because it really, I do think goes to this idea that Tiffany raised, that it is so easy to manipulate those kind of lenses of constitutional interpretation, that sort of watching everyone just picking up the chairs and smashing each other with it. That was pretty fun.
Adam, unless you have something, I was going to jump to DACA. But...
So a couple quick things. I don't think the Chief Justice was originally in the majority. I don't think he would have assigned it to Gorsuch. I think probably Ginsburg was the senior justice in the majority initially. She assigns it to Gorsuch. And the chief comes along for the ride, perhaps because he, having once been on the wrong side of history, according to some, in marriage equality, didn't want to do it again. And in the marriage equality arguments, he was the one justice who in particular focused on this argument about what does sex discrimination mean and how does it apply to sexual orientation discrimination. And then the time bomb, of course, in this decision is the question of what about religious employers? And we'll probably get to that.
Yeah, we're going to get that. So before we do, let's just jump quickly, because this is one that everyone is surely interested in, DACA. Maybe Dahlia, you might have taken it, but I was going to, what's interesting about it is, Dreamers is created by executive order from President Obama. He's unable to pass comprehensive immigration reform, so he takes a different path through executive order. Donald Trump says, look, I'm against this. Don't I get a chance to have my own executive order? He gets to create it. I'm the president. Don't I get a chance to dismantle it? Trump said, I told everyone during the election this is what I was going to do. This is part of my large immigration agenda. Why doesn't the court, and specifically Roberts here again, why doesn't they just say, look, one executive order cancels out the other?
Yeah, DACA, I think, goes to 2 points that Adam, raised that we should flesh out. And one of them is, how is it that this administration just keeps losing? And I think DACA is probably just the sort of blue ribbon example of just do it better. Just don't be dumb about things. And DACA actually reminds me, this time last year, the case that we were all talking about was the census case, where they tried to sort of slap a question onto the census that was going to be a citizenship question, but nobody could come up with a really good pretext. And then Wilbur Ross was saying things, and it was like Keystone Cops. DACA looks like that. They tried to do this DACA rescission initially, by just sloppy and then slightly less sloppy rationales for it. And I think that, what I take away from John Roberts just looking, sort of shaking his head and saying, you can do this. No doubt you have the authority to do this, but don't do it stupid. And I think that in that sense, it very much is like the census question where, I think several people have said, John Roberts is saying, look, in principle, I agree with you. Come back and do this with, legitimate scrutiny of what the effects are going to be on the Dreamers who are deported and what the effects on the economy. And I think that actually mattered a lot to John Roberts, that big businesses and universities were hell-bent on defeating this. But I really think not just this Administrative Procedures Act, which is the hurdle that this administration cannot get over. They can't do the work of doing things correctly. But I also think it really is an interesting case to show the other point Adam made, which is I don't think John Roberts likes Trumpism. I think that he shows amazing solicitude in his majority opinion, not just sort of dismissing how badly this was effectuated, but also a really keen understanding that these Dreamers had a reliance interest in staying in this country. They had built lives around it, that there was, huge economic peril to deporting them. And so I think in a weird way, and we can talk about it in other contexts, he really showed a deep tenderness for how the lives of these Dreamers would be affected if they were subject to deportation.
Right. That's another interesting thing about that. And let me just add this one point, because Donald Trump has had 3 years in office, and he's taken on this, when it comes to the Supreme Court, 3 shots at immigration, right? So it's important to remember, he's basically 1 for 3, right? He wins the first one. That was the Muslim travel ban to certain Muslim countries. He wins that one on some idea that, presidents are in charge of defending the homeland, and there could be terrorism. And the Supreme Court always seems to land on presidential powers for that. But he loses last year on the census question with Roberts, and he loses this year on DACA. So, and it is interesting because it does speak to the idea also that Tiffany said earlier, which is, let's not get too excited, because the court is also saying there's a roadway for you to get this right. If you could just get it right. I am not a liberal. I'm not with you on this, liberals, but I'm not with him because he does it in such a half standard way that I have to support the liberal position.
There's a larger point. Go ahead, Tiffany.
I just wanted to add 2 points to that. One, to your point about understanding the humanity, I would say that Kavanaugh did the same thing in his dissent in the Title VII case, because even though he didn't agree with, he thought that Congress should actually be responsible for making the decision, but he also gave kudos to the gay rights movement, saying, you have worked so hard for this, and this is so important for so many people's lives. And he basically said, congratulations. That was an incredibly human moment from him. But the other thing I would say with respect to John Roberts and him basically slapping these lawyers down, it's worthwhile remembering that John Roberts himself was a really good government lawyer. I mean, I didn't particularly like the work that he did in the Reagan administration and the Justice Department, especially when he was working on the Voting Rights Act, but he was really good at it, very precise.
He would have never blown it.
That's right. And so he's very frustrated, I think, with the professionalism, the lack of it that he sees.
Adam, you had something you should get.
Yeah, look, first to build on Tiffany's point, the Kavanaugh dissent, a lot of people liked. It was a little like the Chiefs dissent in Obergefell, saying, you gay people, you should celebrate even though I can't do it for you legally. Not to everyone's taste. And Kavanaugh really focused only on gay people. He didn't have a word to say about transgender people, which may be a statement about Kavanaugh, or maybe a hint about how these decisions evolved. They might have been 2 separate decisions before they were combined into one. On DACA, there's not only the takeaway that maybe in the particular case of DACA, Trump can get it right, but just wait till, let's say there's a Biden administration, and the Biden administration wants to undo executive actions by the Trump administration. There will be endless citations of the DACA case about why they can't undo executive action by executive action.
I have one more thing to add. I know history is written by the winners, but I would recommend to people who are interested in this case that they take a look at Sotomayor's dissent. And she's on my mind also because, as Supreme Court watchers know, the court has still been busy this week, issuing additional. Adam, what's going on? And overnight, Florida had, in my opinion, a really terrible result in a case about whether felons can vote. Sotomayor writing a dissent there too, and she really is the beating heart of the left. Jurisprudential issues aside, making the case repeatedly that what President Trump says on the campaign trail, which is so egregious, racist, and hurtful about Mexicans, and it ought to matter. And maybe technically it shouldn't, but I guess I'm just kind of glad she's there to add that important reminder. And in other courts with other compositions, it might carry more weight.
Lisa, I kept finding myself wondering if John Roberts of today were hearing the travel ban case, where he was willing to sort of wipe away all of that evidence that Sotomayor really painstakingly curated, saying like, these are the tweets, these are the statements, these are the comments. And he was willing at that moment to say, none of that matters. This is purely about executive power in wartime. But I find myself wondering if John Roberts of 2020 would have been much less inclined to say, it's just his itchy Twitter finger. It doesn't matter. I think in that sense, Adam's point that Trump is really starting to aggravate the justices is really salient.
All right, let's take I'm going to try to combine two cases because they're essentially abortion cases. They go in two different directions, right? But let's try to see if this works so we can actually take more cases on over the next 20 minutes or so. The Russo case is the Louisiana case, and that's the case that essentially was decided a number of years ago in Texas, which required the state required admitting privileges for abortion providers to say, like, unless your clinic has admitting privileges at a nearby hospital, you can't perform an abortion. And so this represents a very big restriction on the right to an abortion. And in that case, again, Justice Roberts, who voted to uphold the law in Texas, but here voted to strike down the law in Louisiana. Again, another Roberts decision. Changed his mind. Maybe we can explain why he changed his mind. But the idea here is Texas is the precedent. And so therefore, this is an undue burden on women to only go to clinics where the doctors have admitting privilege. That's one case. That is in the column of pro-abortion advocates. And then there's the other anti-abortion cases dealing with contraception. Obamacare, we now know from the Supreme Court that an employer can deny coverage for contraception if they have any religious or moral objection to contraception. And the original thinking was that Obamacare would make that covered expense. But now we know from the Supreme Court that, and I suspect some reasons because they'd already made decisions with respect to religious institutions, but it does seem to go one in one column and in a second column. No one's really going to be happy here. Does anyone want to jump in?
Well, we've talked about the Louisiana case already for a second, and the Louisiana case is about respect for precedent. So John Roberts, I'm not sure it's fair to say he changed his mind. If the Louisiana case were coming fresh to him, he would have voted to sustain the Louisiana abortion restriction.
What he did in Texas.
But yes, as he did in Texas. But since there was a precedent directly on point, it would make the court look foolish that merely because there's a change in personnel, they're immediately going to come to the opposite conclusion. It's bad for the court. The chief is the custodian of the court's legitimacy and authority and prestige. He's an institutionalist. And so I agree with Tiffany that it may be a small thing only. I would drop a footnote, though. There was a serious argument in that case that abortion providers don't have standing to assert the rights of women having abortions. Right. And the chief didn't need to reach that issue, but he did. And he voted with the liberals on that issue. And that blocked out a very promising line of attack for opponents of abortion. On the contraception case, we're moving from the constitutional realm to the statutory realm. And it was sort of a hard case. And you could tell it was a hard case because it was 7-2. And Breyer and Kagan were in the majority. The Affordable Care Act itself doesn't say anything about contraception. it says that agencies should draft regulations, and the Obama administration did draft regulations, and it said the 16 forms of contraception approved by the FDA should be provided to women for free. And the Obama administration said, but houses of worship don't have to comply because they may have religious objections. So the precedent for having a religious objection was set by the Obama administration. The Trumpies come in and they have a much broader version of what religious and moral objections apply to, but they're working in the same realm. And that's why in the Kagan concurrence, she says, well, if the only question is statutory authorization, it's a close question. It's ambiguous, but since one administration did it, the other administration can maybe do it too. I'm going to vote with the majority. And then she does the characteristic Kagan move, where she then sketches out for litigators how you attack it when it comes back on remand, which is what she did in the partisan gerrymandering case. And she said here too, I don't know what their justification can possibly be. So hearkening back to DACA and the census, as Dahlia was laying out, it may well be that on remand, the thing gets knocked down again.
But you're saying the argument is essentially if you allow some to opt out, then you're essentially establishing a precedent that opens the door for this opt out, right?
That's one way of putting it, Thane. Another way of putting it is everyone agrees that the statute allows the agencies to have some amount of opt out, and once you're bartering on how much, it becomes a much harder case.
What else on either of those two cases? Because in a way, they're both fascinating in their own way. I love what Adam said, that it would make the court look ridiculous if it allowed Louisiana to do the exact same thing it told Texas not to do. The only point would be, well, now that we have Gorsuch and Roberts, right now, of course we would have a whole different result.
Now, essentially, the same thing happened in a couple of partial birth abortion cases, separated by not much longer span of time, but with Alito replacing O'Connor.
I think it's worth paying attention in the Little Sisters of the Poor case. I think it's worth paying attention to the language about having a moral objection, because you can drive a truck through that. That is an enormous.
Because you don't have to be religious,
Right.
That's
you don't have to be religious to evoke that.
That's right. And I have to say, when I look at the solicitude that this court is giving to religious actors, and in particular looking at the nature of the accommodation that they're giving to religious and moral actors here, it makes me wonder what this court, what the conservative majority is thinking about the old classic peyote case, the Smith case, where the Supreme Court said that neutral laws of general applicability are essentially going to stand. I mean, I don't have any reason to believe at this point in time that that's going to fall, but I do have to wonder to what degree it might be vulnerable, at least, given the way that this particular conservative majority is thinking about an accommodations regime.
And maybe just saying, someone said it earlier, but here, let's say it really explicitly: the court giveth, the court taketh away. And so we just talked about these massive victories for LGBTQ workers in the Title VII case. That actually gets severely eroded in a case about, the ministerial exception
Yeah,
to.
we'll talk about that next.
That's the exact same dynamic we see here, where the court giveth ostensibly a big victory. It is a big victory. I could quibble with Adam about how big a victory it is, but it's a big victory for reproductive freedom, and then gives this, as Tiffany says, huge exemption. And I think we saw that with the Obergefell, right? We got marriage equality, and then we got a cake baker who had religious objections. So I think the one really big way to see this term is that all of that whole column of huge constitutional victories can be hollowed out in really significant way by religious dissenters.
So can we say, if we did this exercise where we just had our abortion and contraceptive case, can we say that when it came to religious liberty, the two cases were giveth and giveth? There was no taketh away, right?
I think it was giveth and giveth and giveth. Because you had contraception, you had Catholic school teachers, and you had aid to religious private schools.
Yeah,
two of those three were 7-2.
Right.
So this is not religious liberty is a liberty, And it wasn't that long ago that, that was thought to be a civil rights issue by people on all sides, and the Religious Freedom Restoration Act was signed by President Clinton.
So before we get into this, let me just tell our audience what we're talking about. The two cases. So there's the one case that arises out of Montana, and the rules basically say, well, we're giving scholarship funds to not just public students but private students, school students. And the question is, well, what about religious schools? Those are private schools. And so the question is, the court said, well, if you're going to give it to some private schools, you have to give it to religious schools. So this was a big victory for religious institutions, religious liberty. But it did seem to me, on some level, to violate the Establishment Clause of the First Amendment. So maybe one of you can jump on that. And then the second case dealt with what's called the ministerial exception, right? And that's the idea that do federal anti-discrimination laws apply to hiring and firing in religious schools? Or is this something called the ministerial exception? It says, well, when it comes to faith, if you're in the God business, we don't tell people in the God business who can teach faith and who can't. And the question in that case was, well, what constitutes God work, faith work?
Yeah.
Because I think those teachers were not even teaching God. They were teaching maybe geography or phys ed. And the question was, well, it doesn't matter. If they're teaching in a religious school, they're teaching God's work. So in those cases, they both supported religious liberty. So now that we've set those up, let's talk a little about that.
Well, maybe let me talk about the schools case for a second. You said there's an Establishment Clause problem, and that is intuitively right. But in fact, this was a free exercise case. The court has already said that if states want to, they may subsidize religious schools. So they're free to do it. The question is, what do you do in those many states that have state constitutional provisions that says we don't want to give aid to religious groups? We don't want to give aid to religious schools. So in a way, it's a federalism question. And the court says no. The First Amendment's free exercise clause says once you're giving to any private school, you have to include religious schools.
And didn't this happen, to remind me, it was when we did Law of the Land a few years ago. I don't know whether you or Dahlia were with us that night. Didn't this happen with the similar program of renovating school backyards, playgrounds?
Yeah, Trinity Lutheran said you couldn't exclude a program that subsidized soft surfaces for school playgrounds. Fine, okay, but that has nothing to do with religious work.
Right.
And also, I think that, if we're trying to get into the complicated head of John Roberts, this is a really good place to flag that, when we say he's playing the long game, this is a thing that he does where he does it little in this totally seemingly sensible case about, come on, we don't want kids at Trinity Lutheran to break their heads on the playground. Let's give them the rubber surfacing materials. And then that opens the door a few years later for massive expansions of those. So I think, again, one of the reasons I'm on Team Tiffany about June Medical is because I think that every time he says we're going to just limit it to this one little thing, he pops out of the Jack in the Box a couple of years later and just bow.
Because you're saying the rubberizing surface thing was a great way to get in to this discussion, right? Oh, give me a break. You don't want to put rubber surfaces to protect religious students if they fall off something, right? And so that establishes the precedent that really it opens a door, but is it the same thing as what we have here? And one could make the argument it's not. But in his mind, he opened the door. Anyone else on this, on either of those two cases, ministerial exception case or the scholarship? What about the ministerial exception?
The ministerial exception case followed a case called Hosanna Tabor a few years ago, where the court unanimously said, if it's an authentic minister, the government shouldn't be involved in telling, religious groups whom to hire and fire, because the internal workings of religious work is for religious people. Now we go from unanimous to 7-2, again with Breyer and Kagan in the majority, saying that Catholic school teachers who, along with teaching math and science and English, spend half an hour a day teaching Catholic doctrine, were religious enough. And now the question is going to be, what about the coach? What about the janitor?
Right. And also, what you just said, let's not forget, that was Breyer and Kagan joining the majority in that case, in both of those cases, right? And so we never think of them as religious liberty people, but they were this year.
Yes, so they were in the contraception and teacher cases, not in the aid to religious schools case.
Oh, that's right. Not
That
the
was 5-4.
Not the Montana case. Okay. Let's talk about the Electoral College case, because that could have actually played out in this next election. And then maybe we'll talk about some other things related to this next election. This is the idea of the faithless elector. When the Constitution was written, they created the Electoral College. It said states have an obligation to put up your electors to represent your state, and they have to vote. So the question is, what does vote mean? Does this mean they can vote whatever they want to do? Or, as it's been interpreted for a couple hundred years, no, you don't get to vote what you want. You vote the way the state votes, right? But we had, in the last election, we had a few what we call faithless electors who went rogue. They voted whatever they want. I think one of them voted for Colin Powell. He wasn't on the ballot, right?
Yeah.
Right? They voted their own way. And the question is, what would have happened, or what could happen this next election? Because, normally we don't have, the faithless elector would have made a huge difference in Bush v. Gore, right? Right.
5 votes.
5 votes. It wouldn't have made a difference in Trump v. Clinton. But if it had happened Bush v. Gore, faithless electors could have changed that election. There are people, I suspect, that are worried about this. So the court basically said, what? Chaos, right?
Yeah. Justice Kagan gave a, breezy, obligatory Hamilton reference. I think she threw in Veep just to make it lively, and it is worth reading. 9-zip opinion. I'm going to say probably the least controversial voting rights opinion we're going to see from this court, maybe ever. And there are some other cases that obviously have been much more hard fought and with much worse consequences than this, if you ask me.
But it shows the court doesn't take originalism very seriously, because the originalist argument for letting electors vote their conscience is very strong. Hamilton said in so many words, people out in the hinterlands, the very poor communication back in those days, didn't have the means, the ability to make judgments about presidential candidates. So you should get good men, wise men, send them to Washington, they could decide.
Right.
Also worth noting that the Chief Justice wrote all about Aaron Burr in his majority opinion in one of the financial documents cases, which does seem to suggest that they were all trapped in their homes watching Hamilton on Disney, just like the rest of us.
Speaking of election, we've all said a lot about Roberts. I love what some of us, Adam, push this argument that, we can get a sense that that Roberts is not a fan of the Trump administration, the way they do business. But do you think that the looming election played a role with a pandemic and 6 months to go in an election after a Senate impeachment case in which Justice Roberts presided over the Senate, right? He was busy at that time. There was no pandemic, and he was serving as the justice in an impeachment trial in the Senate, at the same time serving as the Chief Justice. And he's basically, sat there and listened to all the evidence or the non-evidence that happened. And now all of a sudden there's an election. Do you think that they were thinking about this, that we do not want to come across as a partisan court or especially ideological court? We don't want to appear as if we're in the back pocket of Donald Trump, unlike the Ukrainians. We don't want to do that. I'm wondering whether the justices may have been thinking about this looming election.
I think yes. And moreover, the justices are sensitive to all the talk you hear from Democrats about wanting to expand the size of the court, about court packing. And just as FDR's court packing plan failed in a sense, we didn't expand the size of the court, but succeeded in an important sense because the court started upholding New Deal programs. I think something similar may have gone through at least Chief Justice Breyer's mind, that if he could model for the nation something like a nonpartisan court, it would take the air out of that particular court packing balloon.
Wow, that's great. I love that. Anyone else about the politics of the court, recognizing an election is coming up? But by the way, while we're having this discussion, if you want to jump in on another point, apparently course, the former Vice President Biden has already told us that his first pick would be a female African American. Am I right? I think I have this right. That he's already committed himself that
Yes.
if you elect me, you will see a female African American justice. Very much in the spirit of Donald Trump telling everybody 4 years ago, I'm telling you, I'm going to pick, pro anti-abortion justices. Talk about politicizing the court.
I think for one thing, I completely agree with what Adam just said about what Roberts may very well have been thinking, especially given all of the chatter about court packing, expanding the court, et cetera, expanding the lower federal courts. But with respect to what former Vice President Biden has said, I will say that I don't know that the left responds to arguments about the court the way that the right does. I suspect that he made that promise in part as a way to try to shore up the African American base and parts of the rest of the liberal base. And, if the left paid more attention to the court, I think that Hillary would have won. So he's made the promise. I presume he'll keep it. People tend to keep their promises, or at least try to. But I don't know that is going to be the promise that is going to drive people into the booth on election day and actually cast a ballot for him.
Even though it should to some degree. I'm wondering, does anybody here have a thought of who that woman is?
Well, naturally, it's Anita Hill.
There are so many you could choose. I know too many women in the Academy.
I like Leandra Kruger on the California Supreme Court.
Stacey Abrams.
Stacey Abrams, Leandra Kruger, Michelle Obama.
Michelle Obama. And you were serious about Anita Hill?
No, I wasn't really serious.
Yeah.
But I think Anita Hill might have been on his mind when he was making that particular promise.
For the reasons that has to do with his own role in the Thomas nomination.
Right.
Can I make one serious point, which is, we've been talking about the Supreme Court, but it's certainly worth mentioning that Donald Trump has seated 200 federal judges on the appeals courts and the district courts, and that they obviously hear in a year where there were 53 merits cases at the U.S. Supreme Court, the vast bulk of decisions will come from courts. Circuit courts have flipped now, and that leads me to the other point that I think Lisa made right at the outset, which is if one were to make the mistake of thinking that this court is really, really neutral or, maybe anti-Trump, it's certainly worth looking at the 3 voting cases that have come up, the disenfranchisement of Florida felons that she mentioned, but also the 2 COVID cases from Wisconsin and from Texas, each of which would have given a court that authentically wanted a fair election a chance to be very mindful of disenfranchisement, very mindful of the fact that we're, I think, careening into the catastrophe of the November election, and a court that doesn't seem super, super interested in making sure that happens fairly.
So the point, Dahlia, and I think everyone would agree that even for people or Donald Trump himself, who would be disappointed in the voting of his 2 picks for this year, he can still point to his base and say, but let me tell you where the real value of a Donald Trump administration has been. I have packed all the appellate and district courts throughout the country. I have been spending all my time picking court justices and judges for the appellate courts and the district courts. And that's really why you need me in office now. Maybe Gorsuch and Kavanaugh might have broke our heart a little, but I'll tell you who didn't break our heart, the appellate judges and the district court judges. Before we take maybe a question or so from our national audience, let me just quickly get to the gun case. Because it's set in New York, and we are, New Yorkers for now, even though we have a national audience here. Because here is an opportunity for the court to have stepped in more broadly and played a role in favor of supporting the Second Amendment right to guns, and they chose not to. And I wonder whether you think that because there are other cases coming up, cases about the right to carry guns. The idea of putting a restriction on the ammunition, I guess the maximum capacity ammunition. I think there's even a case dealing with, can criminal defendants, felons, can they own guns? But this case originated out of New York, and it was a restriction to say you can't take your gun out of your house and leave the city with it. And you can only use it at a driving range within the area. And so don't tell me why it is the Supreme Court didn't overturn that. And by overturning it, it would have invited more of these. I would feel that the gun lobby would have been feeling much better about some of these other cases coming down the pipe. Anyone?
Well, if no one else is going to go. What happened, Thane, I think, as you know, is that New York City, once the case reached the Supreme Court, promptly repealed its kind of stupid law. The law said, you know, if you have a vacation home, please leave your gun at home to be burgled. Don't take it with you to protect yourself at the vacation. So the law is repealed, and although there was some back and forth about it, once repealed, there's nothing left for the court to decide. They were frustrated; they had nothing left to decide. The much more interesting question is, everyone thought, okay, so they got rid of that case, they'll take another case, and they had like 15 cases lined up. And they had a conference about them, and they took precisely 0 of them. Even though in some of the dissents in the New York case, there was definitely dissents from Kavanaugh and Gorsuch and Alito and Thomas. Please bring us another case. We're ready to make some Second Amendment law. And then they didn't. And that makes you think that they're not confident they have 5 votes. And if they're not confident they have 5 votes, the 5th vote they're not confident of is Roberts.
You're saying that they actually had cases they were really interested in. That they could have taken.
And I, you know, Dahlia can back me up. Everyone was sure they were going to take one of them.
Yeah, and Clarence Thomas, I think, you know, almost standing on the rooftop screaming that the court hasn't taken a significant gun case in a decade. And he uses the words like abdication. Like, he is furious that these cases are not being taken. And he's really made it a point of sort of shaming the other justices. And still somebody is going to blink. I think Adam's exactly right, that they just feel exactly how they felt, by the way, about Anthony Kennedy, which is if we take, it only takes 4 to grant cert, it takes 5 to win. And I think they feel if they don't have that 5th vote, they're going to go backwards.
All right, let's take one quick question. Adam, you want to add to that? Oh, one quick question from our audience, and then we'll say goodnight. This question, is Roberts, Chief Justice Roberts, concerned with his legacy or with preserving the integrity of the Supreme Court in the separation of powers? We've spent a lot of time talking about Roberts tonight. In fact, I don't remember in the 6 years that we've done this, whether we've spent this much time talking about one particular justice, potentially the Chief Justice. And here's a question from the audience saying, well, what's driving this guy? If he was making a statement this year, what was the statement and why was it being made?
So the answer to the question, go ahead.
I was going to say, I think there's a lot to this argument that Roberts is concerned both with his legacy and with preserving the integrity of the Supreme Court, precisely because we are in such a hyper-polarized moment in our politics that if he doesn't pay attention to the integrity of the Supreme Court, the court is going to, we're going to hit a point where we're just going to pay less attention to, let me say that differently. We still pay quite a bit of attention to the court. Many of us do. But if he doesn't pay attention to the integrity of the court, he risks the possibility that we will not. I mean, you think about what happened after Brown versus Board of Education when the South just revolted. They just didn't listen. It's not outside the realm of possibility that something similar could happen again. And I don't think Roberts wants something like that to happen on his watch. So it would not surprise me at all if he made some political calculations in terms of some of his votes, because Roberts is frankly a pretty good politician from what I can see.
Adam, did you have something?
No, Tiffany's exactly right. The answer to, is it legacy or is it the institution's reputation, is yes and yes. Both, and they're quite intertwined.
Okay. All right. Before we say goodnight, a couple of things. First of all, folks in the 92Y throughout the pandemic, we have not shut down. It's important for you to know. We're providing programs, and folks, we've really, it was a shocking number of programs that we still have throughout the remainder of the summer. Same thing with 92Y. Remember that about us, nonprofits always can use your support, and also keep tuning in. If you're not already on folks.org's email list, please, folks.org, 92Y. And so speaking of programs, the 92nd Street Y on July 21st has what they're calling a master class. This one is hosted by Bret Stephens, the New York Times Pulitzer Prize winning columnist. At Folks the day before on July 20th. Adam, do you have that slide? Yeah, there we go. We have this new series called Conversations on Essential Cinema. We have the actor William Fichtner, and we'll be discussing The Graduate. So if you're interested in talking about listening and hearing about The Graduate, you can watch it over the weekend and come on the 20th and watch it with us and at no charge. And then our next one, which was that one. We have one more, another. Yeah, there we go. We have other events throughout the summer, but I just wanted to announce this one on another Conversations on Essential Cinema, August 26th, Casablanca. Yes, the Sharon Stone will be with us. That should be fun. And if you're an aspiring filmmaker, let's move to the next one. Yeah, we go, Andrew. There we go. The call for entries for our International Short Film Competition. 20 minutes or less, a film that's made about justice, injustice, morality. This is incredibly popular. We have a red carpet. We give out the Folksy Award every year. So if you have any aspiring filmmakers in your life, let them, and we have them from all over. They're literally international. We get them from South Korea, Iran. It's really extraordinary. Everybody wants to submit. Adam, are you going to submit this year?
Of course.
Okay. All right. I want to say goodnight to our really special guests and friends. It's important to point out, thank you. I can call my friends to come out for Folks that really do appreciate it. Adam, Dahlia, Lisa, and Tiffany, please come back again. Thank you all. And good night from the 92nd Street Y and Folks. Keep tuning in. We're still here for you. Thank you. Good night.